All right, everybody, welcome to today's session of our campus chats and coffee. I am enjoying a nice cup of coffee this morning with my assorted cat mug. It says cat person in it because we have one that says cat person and dog person because we have one of each in the house. I hope you are also enjoying a warm beverage or something of that nature. And we're going to be talking through some of the legislation that we have here in Connecticut that helps to protect survivors of sexual violence on our college and university campuses. So first, we're going to be talking through this bill that got passed into law. We'll be accompanied through this journey by my dear friend Bill from Schoolhouse Rock. He is present here. But all of these bills are indeed laws. So Public Act 1411 extended some protections from some 2012 legislation that we had here in this state, but it speaks to what institutional policies need to look like to an extent, anonymous reporting methods, public reports, which we're going to be speaking more about next week, so I'm not going to get too into, but essentially it talks through what needs to be reported to the state and available to the public every year in Connecticut. The development of campus resource teams, the necessary development of a memorandum of understanding, and different training requirements. So in regards to these institutional policies, regardless of where sexual violence occurs, there does need to be a policy in place to address sexual violence. So this really provides a layer of protection given the Title IX regulations. Essentially, campuses in the state of Connecticut are in a position where they would need to still be responding with some sort of internal policy. While there's more flexibility as to what that would look like than there may be for Title IX, there needs to be something in place. So students who report sexual violence need to have concise written contact information for services. So if they do report having this experience, they should be told where counseling services are, where they can seek advocacy, on campus and in the community. So the local crisis center, right? The information for an advocate there. But this is all information that they should be provided upon disclosure, no matter what route they choose to take, in terms of reporting and moving forward in the future. So individuals who report also have a right to be informed of their rights. So they need to be told what their options look like in regards to reporting. They need to know about what orders of protection they could potentially seek in the community through the criminal justice and court system. And they need to be told about accommodations that are going to be made available to them, as they must be made available to them. So when we're talking about those accommodations, we're talking about the reasonable accommodations that someone whose education has been disrupted by an instance of sexual violence, intimate partner violence, or stalking can achieve. So that could look like ability to move their housing, ability to change their classes, or ability to change their campus work situation. It can also create transportation changes for them, so they could have accommodations to transportation to ensure that they have access to their education and feel safe. It also outlines a good amount of what these disciplinary procedures need to look like. So students do need to be able to engage in these processes on a prompt basis, right? So this is something that does need to occur promptly, whether it is a Title IX or an internal disciplinary procedure. These disciplinary procedures do need to be conducted by a trained official, right? So if you have someone in a Title IX office, that person does need to be trained in order to have that role under, of course, our Title IX guidance. However, if you have other individuals that are going to be involved in sort of a non-Title IX internal process, they still need to be trained to ensure that they are going about this in a way that is not going to be harmful and is going to protect the rights of that student. They always need to utilize the preponderance of evidence standard. So the federal government gave institutions kind of a choice whether they wanted to utilize that standard or the clear and convincing evidence standard. This is a more significant standard of evidence. So essentially more evidence would need to be found in order for someone to be found responsible. The preponderance of evidence standard is more equitable. And so it's more appropriate in these cases. It's what is applied to other civil rights laws. So it would be sensible that it would be applied in these cases, but it is what needs to be used in Connecticut for disciplinary procedures. A survivor going through this process also has the ability to have an advisor of their choice. So they need to be able to choose who they would like to have through this disciplinary procedure kind of at their side, and need to be given some suggestions by the institution should they be unsure as to who they would want in that position. They also need to be informed of the conclusion of the procedures. So when ultimately there is a finding of responsibility or not responsibility, or there's a less formal case going on that has come to its conclusion, they do need to be informed that it is concluded. So if somebody is unsure whether or not it is concluded, either they have not been afforded this or it is not yet concluded. Somebody's identity does need to be protected through these procedures. So it's important that their privacy continues to be protected. Well, of course, FERPA is going to apply. Sorry, my dog is scratching the ground. Bambi, lay down. So while their identity is going to be protected under FERPA to an extent, this just ensures that their identity continues to be protected and this continues to be prioritized by the institution. There's also a summary of employee procedures that needs to be, essentially on record, so it can be referred to ensure that everybody is, keeping to these situations where somebody may report against, an employee or regarding an employee at the institution who has potentially perpetrated sexual violence, given that this might look different. And then additionally, there needs to be a range of sanctions that the institution can refer to that they can also share with the individuals involved with the case to let them know what sanctions could potentially look like. So there really is a lot that needs to be included in these procedures, which is really helpful given that we know that there are many cases that no longer fall under Title IX, but they can fall under these institutional procedures. So knowing that there are certain nets of protection for these students who no longer fall under Title IX is definitely critically important. Additionally, there needs to be some anonymous reporting mechanism. So institutions must provide the option for anonymous reporting. They must inform the student or employee of obligations under state and federal law. In terms of any obligations that they would have to report in regards to campus safety. So under, the Clery Act, for instance, if there were an issue of campus safety that needed to be addressed, the institution would have to act. So they may have to, at that point, reveal the identity of the person who has made that report for the purposes of gaining more information from them. However, wherever they do not have that federal obligation, they must provide that mechanism for anonymous reporting and keep that person's identity anonymous. So the campus resource team is also a resource that institutions need to develop. It's a collection of campus and community personnel, and the legislation actually lists out who needs to be included on that team. It does include an advocate from a local crisis center, which is many of you watching would be included on the campus resource team. And every campus in Connecticut does need to have this team in place. These individuals need to be educated in awareness and prevention of sexual violence, the institutional policies that exist both under Title IX and other than, what laws it falls under. So, things like, the state laws that we're speaking about today, because these are laws that apply exclusively and specifically to Connecticut, right? So they would need to understand what those look like, as well as other federal laws such as Clery. They need to be trained in a victim-centered response, which really they do outline what that means in the legislation, but essentially it means sort of ensuring that there's an understanding of what victims' experiences may look like, and the challenges that they face, what trauma looks like and the way that that plays out, and how to ensure that you're always sort of honoring survivor choice. But again, it's laid out and prescribed in the legislation itself. More specifically, they need to understand the rules of the different members at the table. So they need to understand who everyone is and why they're there. In fact, it actually states that the individual who is representing a local crisis center needs to be invited to provide a presentation about their role so that the members all understand who they are, why they're there, and what service they provide. And the advocate also needs to understand what the roles are of the other folks at the table. And then also they need to be trained about diverse cultural backgrounds and the way that that can play into some of the cases that they may see, to ensure that they're being culturally competent through whatever services they're providing. Campus resource teams are going to meet at least once per semester. Of course, they can meet more, but they do need to be meeting at least once per semester. And they need to review and update protocols. That's essentially, the primary purpose of those meetings is to ensure that they're all up to date on protocols. And if there are any changes to state or federal law that would require them to update them, or further knowledge of best practice, they would do so. In regards to the memorandums of understanding, the MOUs, this ensures that survivors can access free and confidential counseling and advocacy whilst being students on their college or university campus. So every institution in the state of Connecticut does need to have an updated MOU with a local rape crisis center. So this establishes a long-term partnership with the school. It ensures that the advocate is involved in the campus resource team. And it also establishes different trainings between the school and the center. So it ensures that the advocate is going to be involved in training programs at the institution. So that's sort of the basis of it. Of course, institutions can of course sort of add more, as can, and crisis centers can negotiate what else would need to be on that or what else should be on it. And the language can look a little different, but at the base of it, that is what needs to be included within that partnership. In regards to training requirements under our state law, the Title IX coordinator and the campus police and safety personnel do need to go through training on an annual basis. They need to learn about the neurobiological impact of trauma, and so what that's going to look like if they're talking to a trauma victim, and how to best work with that person with the understanding of that impact. They also need to talk through the impact of different societal myths around sexual assault and how that is going to impact the case and the individual's perception and understanding of what they're going through. They need to be educated as to the behavior of perpetrators of sexual violence. So what that different trends may look like in terms of their own behaviors, how they might act through a case, things of that nature. And then effective investigation techniques. So if somebody is going to be investigating an instance of sexual violence, what are some ways to go about that that are going to be effective given the unique nature of these cases? All right, so I apparently forgot to change the bill number, but this is a public act that was passed in 2016. And this was our affirmative consent bill. So it defined affirmative consent in statute, and it required the use of the term affirmative consent for programs and processes here in Connecticut. So in the state statute, it actually really outlines what the affirmative consent is going to look like. So while the institutions can have their own individual policies, they do need to include a number of certain elements. For instance, they do need to explain that affirmative consent is something that may be revoked, right? If somebody consents, that they may revoke their consent at any time, and anything that happens following, them revoking that, if activities continue, those are sexual violence. That consent must be sustained throughout sexual activity. Consent is the responsibility of each person to get from the other person, rather than somebody's responsibility to give, if that makes sense, right? So rather than asking, how did you resist, or how did you, kind of show that you consented? The question more so starts to shift to, how did you ensure that this person was consenting, right? And you were getting consent from them. A past relationship is not an excuse for any instance of sexual activity without that person's consent. So somebody can't just say that because they had a sexual or intimate partner relationship in the past, or currently do even, that excuses sexual violence without consent, and consent needs to still be held to the standard regardless of any relationship. And so, lack of affirmative consent is not an excuse, right? So, for instance, if somebody is intoxicated beyond a point where they can consent, if they are asleep or otherwise incapacitated by drugs or alcohol, that person cannot be consenting, because they cannot, somebody would not be able to get consent from somebody who's in that situation. If somebody essentially recklessly disregarded, that other person and was unable to get their consent, because of their behavior in that sense. If they essentially failed to take reasonable steps to get consent from the other person, checking in, things of that nature throughout the activity. And then if they known or should have known that the victim was unable to consent. So essentially saying that they didn't know that that person was that drunk, right? And then that if there was a report of sexual violence in a situation like that, somebody would be in a situation where, if they should have known, right, if that person was having trouble walking or having trouble speaking, then even if they state that they didn't know, if they should have known, then that is a situation where, if any reasonable person would have been aware, they should have been aware, and therefore they are still held responsible. Additionally, their own intoxication would not be a reason for being able to excuse these behaviors. All right, and then one of my personal favorites, Public Act 2181. So it is a personal favorite because I was involved in the development of this legislation. And ultimately, I am now sitting as a chair on the council that this legislation developed. So this bill, now law, requires that annual assessments be conducted every year. And about campus climate, so about instances of sexual violence, and there are different data points that need to be collected, such as students' perception of campus safety, There's a council, actually, again, the council that I'm chairing, and we need to come up with some tools that we recommend for assessments. We need to recommend, there are 4 different data points we need to hit, so we need to recommend ways that they can ask those questions, and then implementation guidelines, and then there's an amnesty provision for survivors. So again, our council is tasked with suggesting these different data points and tools, as well as providing guidelines for implementation of campus climate surveys based on best practice. And then the institutions do need to be conducting these assessments every other year. And they need to publish the results of those assessments on their website, and then include a link to those assessments to the Committee on Higher Ed at the legislature. So that would be published on the legislature's website as well, and be able to be reviewed by that committee. So there's sort of that public report element to it as well, to kind of tack onto other public reports that they're required to be submitting, which we'll be learning more about in our next session. There is some federal legislation at this time that is going to potentially change the way that this is going to carry out. However, there are different added protections and an added level of involvement that, you know, this council has in sort of the operations of these institutions that will continue to operate through Connecticut, no matter what these sort of federal changes will kind of bring down. And then in regards to the amnesty, which was something I was really adamant about, and in, you know, the inception of this legislation, and then throughout. So this applies to any student or employee who somewhere within the narrative of their experience of sexual violence, there is something regarding drugs or alcohol. So when an individual comes forward and reports that they experience sexual violence or were witness to sexual violence, but, you know, need to bring up drugs or alcohol, and there may be some campus policy that restricts their use of, you know, drugs or alcohol without that sort of disciplinary procedure occurring, they can no longer be held under those disciplinary procedures, and no disciplinary action can be taken against that individual when they come forward to report sexual violence. So they have that protection. Of course, it does need to be a report made in good faith. So essentially a true report. So we know false reports are extremely rare, but in the case that somebody did make a false report, and so therefore that report was not in good faith, that amnesty provision would no longer apply. And additionally, the institution may have to intervene if they were to put the health and safety of others at risk. So say they were, you know, recklessly driving drunk through campus, the institution may have to address that situation, right, regardless of the amnesty provision. But these are not situations that we see come up often, where anybody put the health and safety of others at risk, nor make false reports. So, you know, while there are these exceptions, we would anticipate that those cases would be very, very far and few between. So that's all I got for you today. So in talking about what's next, we are skipping next week. Happy Passover and Easter to any of you who are celebrating. Happy spring holidays for whatever you may be potentially recognizing next weekend. So in honor of the day that folks have off and the holiday weekend, we will be skipping next week. However, on April 22nd, we're going to be reconvening to talk through public reports because there are a lot of them, and Connecticut has an added layer of them. So we're going to be talking through how to kind of dissect that and figure out what's what. So that will be, as always, Friday at 10 a.m. and it'll be posted on the Monday morning following on our social media. So thank you so much for joining me today, and I hope that you have a great afternoon.
Thank you.